Okay, so just moments ago, the United States Supreme Court wrapped hearing oral arguments in a high-stakes case that could have major implications all across the country. So the justices debated a challenge to the Louisiana redistricting map effort. At the center of the argument, whether this new map violates a provision in the Voting Rights Act that bans racial discrimination in redistricting efforts. You're looking at it right there. So leaders from Louisiana expressed some pretty major frustrations, not only about the map, but the process. And then look at this. Outside, demonstrators took those frustrations to the steps of the U.S. Supreme Court. Right there, you see on your screen through our monitors, that was the scene as so many people knew on the inside those oral arguments began. In fact, you see the signs there, unfair maps equal white supremacy, some pretty heavy statements there outside. Signs and shirts calling for the end of what they believe amounts to voter suppression, with phrases like Black Lives Matter, Black Voters Matter, protect our vote, and protect people, not power. So just moments ago, Louisiana Attorney General Liz Murrill spoke about the arguments before the justices. Listen.
So we've said all along that you have to look at how the population is distributed and look at how maps can be done legally and constitutionally. And that was the basis on which we defended the first map that we drew that was part of the Robinson litigation. And so, you know, I think that we've been over and over this argument about proportionality. Proportionality is not the test. And so, you know, I think we are all bound by the rules that apply. And the court has made that even more difficult with confusing precedent on telling legislatures what they can and cannot do.
So moments ago, there's another side of this. Lawyers from the Legal Defense Fund also spoke out. We wanted to let you hear their remarks.
Just leaving the court after arguing Louisiana versus Calais, where the court asked some very challenging questions about the future of Section 2. We feel confident that if the court relies on its precedent, if it continues to have a commitment to the 15th Amendment and to this project of multiracial democracy, that it will rule in our favor. There has been no change in conditions or the law since it decided Allen versus Milligan a mere 28 months ago, where the court reaffirmed the constitutionality of Section 2, where the court rejected many of the specious arguments that our opponents have asserted on this second argument of the case. And so we feel very confident that the law is absolutely on our side. I want to take a moment, though, to thank our plaintiffs who have continued this fight, this battle, not only for fair congressional maps in the state of Louisiana, but fair legislative maps, fair judicial maps. It takes the will and spirit and courage of everyday people and voters to put themselves on the line, to commit themselves to often a very long and protracted project of ensuring our democracy. And while we are fighting for the rights for Black voters in Louisiana and across the country to have an equal opportunity to participate in our electoral process, that win is a win for democracy. It is a win for all Americans. It is a win for the rule of law. And that is why we fight, because we believe in the future of this country, and we believe that Black people have a right to be part of it and to self-determine who will represent them and to be part of the future of this country. And that is what Section 2 of the Voting Rights Act secures, and I'm happy to take your questions.
All right, so that is the after and what happened outside, but let's bring in CBS News legal contributor Jessica Levinson, who listened to the arguments on the inside for several hours. So what's the focus, and are you getting from the justices in any of their questions sort of a sense of where they're leaning, Jessica?
I think we're getting a sense. Over 2.5 hours of questions, Reed. And as you said, this is a hugely consequential case, and it asks us about the continuing strength of Section 2 of the Voting Rights Act, which, generally speaking, prevents vote dilution on the basis of race. So I want to kind of focus everybody, I think, on the conservatives, because it seems clear that the liberals are comfortable upholding Section 2 as it exists, and more specifically, upholding the cases that interpret Section 2. So when it comes to where the conservatives are, I think that there might be some disagreement about whether and to what extent race can be considered when drawing in the first instance or redrawing in the second instance district lines. And Reed, I think it's really hard to read the tea leaves here, but it looked like towards the end of the arguments that there were justices who were coalescing around a proposal that the Department of Justice had provided, which is essentially I don't want to say compromise, but more of a middle ground where maybe some of the precedents are, as Justice Barrett said, weakened, or she said clarified or modified. I would argue maybe weakened, but that Section 2 remains as part of the Voting Rights Act. It remains as a protection for individuals and their voting rights, but that it might be harder to bring those cases, and some would argue harder to remedy violations.
Well, and we know not only Louisiana grappling with this, but many states, including the state of California and others. And if other states hinge it on this same question about the Voting Rights Act, as so many protesters outside do, is the Voting Rights Act at stake here?
Well, we have to see. So what happens in Louisiana will determine what happens to the Voting Rights Act everywhere, because of course this is about Louisiana. This is about a situation where Louisiana drew district lines where there was one majority Black district. And there was a finding by the district court that there was a likely violation of the Voting Rights Act. So Louisiana went back and drew lines where there were two majority Black districts. And that's the case that has gone up and down and is now the case we're talking about that was heard before the Supreme Court. But it's, of course, not just about Louisiana. So depending on what the court says and depending on how strong Section 2 continues to be, that obviously applies to every state throughout the nation. And there, I have seen political scientists indicate that if the justices do significantly weaken, let's say, the power of Section 2, that could allow Republicans to draw district lines that would essentially lock in a Republican majority of the House, potentially for decades. So this goes well beyond Louisiana when it comes to consequences.
All right, Jessica Levinson, always great to talk to you. Thank you so much.